a 28-year-old kid. Well, not a kid anymore, but we were able to freeze his age so that he's 20 years old, 364 days young, to be able to qualify as a minor on his parents' application to get a green card. This is the craziest CSPA case, and there's a gray area of the CSPA law that we want to share what we did. The date USCIS received the application should be the date to freeze his age. But let me get into that. This is how we got him the green card. Hi everyone, my name is Joseph. I'm the managing partner here at Tsang and Associates, where we solve legal problems with creative solutions. So the legal problem is that his parents filed for the EB-5 application, green card, investment, spent a lot of money. They got the green card, but by the time they went to the interview, the child was over 21 years old already. The child has come to the US, studied, and got a job and everything on other visas, but now last year, the CSPA law changed, allowing for people to apply with a new calculation in the US. So we took the new law and recalculated what his age would have been if the law was in effect. We argue that the date USCIS received the application should be the date where we freeze that age. And so we used that and we were able to bring it down one more day, or like a few more days. So his age is officially 20 years old and 364 days. I have the brief here, right? So I'm gonna read that part to you. The time the 526 was processing was 1 year and 61 days. And then we argued the date the 526 petition was received should be included. And therefore, when you add all that up, it equals the CSPA age of the derivative applicant was 20 years old and 364 days. But the most touching part is the end, the conclusion. We always do this, right? Our client has been maintaining a student status in the United States for more than 11 years, right? Our client has earned a bachelor's degree and a master's degree and has adopted the American culture and working towards a career. This new CSPA guidance provides hope for the status and the family to be in the United States. We believe that the applicant who has been in the US since that time is protected under the new USCIS new guidance regarding CSPA, and it's eligible to apply for the 45 application as a principal applicant. Thank you for your consideration, and please contact me if you have any additional questions. And then we provided all the exhibits. It's absolutely a crazy case, right? CSPA, you're like being a wizard. You're able to freeze people's ages at certain times, and you're able to use the old law plus the new law to be able to qualify for a particular benefit. And if it wasn't for this, they would have to get a green card through another investment or through marriage with a US citizen or to be sponsored by a company and could wait another 10 years. I wish that law and AI would be so sophisticated that when sometimes a little policy change like this, if you should get a green card, the green card would just magically appear in your mailbox, right? You think like if I qualify, the government should just adjudicate and give it to me. But the truth is, in this world, in America especially, you have to fight for your rights. You have to claim it, you have to request it, you have to prove it. The burden is on you to achieve it. It was a very high risk because we don't know if it will work. We've heard of stories of people saying that you can try to claim that the date USCIS received it can be frozen, but there's no like law that says that, and I can't cite to it, right? We can only try. The case got approved and now green card. So it's amazing. If you have any questions about CSPA, if you just learned about this, please refer to our other videos that talks a little bit more in depth on how this is calculated. But very happy to share this story with you. If you have any questions, feel free to reach out. Take care. Bye-bye.